ایرا دنگ رادیو کردانه است لباژیری لاهه
دنگ گشتی آزادی خوازیل و دموکراسی خوازیل دولات کردستان
دنگ ادب و هنر و شهرستانیت
دنگ آشتی و دادپروری و یکسانی
دنگ ولات خمان کردستان لرستان و لکستان
دنگ خشکایتی و برایتی گشت مردم زورله کریای ایران.
بینندگان و شنوندگان عزیز رادیو کردانه، امروز اولین روز دادگاه ایران تریبونال برگزار شد. دادگاه رسیدگی به جنایات رژیم جمهوری اسلامی در سال 60 تا 67 و به طور خاص اعدام‌های خونین سال‌های 67. این دادگاه 3 ماه گذشته در ماه خرداد در لندن برگزار شد که دومین جلسه این دادگاه امروز، فردا و روز شنبه در شهر لاهه هلند برگزار می شود. توجه شما را به اولین قسمت این برنامه جلب می کنیم.
Commission's report explains executions. I have one reference to make. Please look at page 359. 359. At the bottom of page 359, the court will see this. The executions in Divan prison took place behind Ward 4 twice a week, on Mondays and Wednesdays. The prisoners were lined up in a group and executed. Prisoners in Ward 4 could hear gunshots, and by the number of gunshots, they could say how many prisoners were executed. Up to 400 prisoners were executed weekly during my imprisonment, and this is the evidence of a witness who gave evidence of position 62 in the commission, whose name has been redacted. Up to 400 prisoners were executed weekly during my imprisonment from November 1981 to February 1982. Chapter 2 explains these executions, which dotted the map of Iran with blood. The Commission was presented with hundreds upon hundreds of names. Before 1988, some prisoners were hanged or killed under torture, but the overwhelming majority of executions were, as witnessed by Witness 62, conducted by firing squads. I move swiftly on to Chapter 3 of the Commission's report, which provides a detailed and thorough account of what particular abuses were committed in each of the tens of prisons and detention centres, for it was not simply one centre. The sheer scale, we submit, of the operation, for want of a better expression, cannot be underestimated. The Commission heard evidence of 32 separate prisons, half of which received only one mention from amongst 75 witnesses. Again, moving without any disrespect to that category of evidence, to Chapter 4 in the Truth Commission's report, which outlines the experiences of a specific group of people imprisoned in the jails of Iran during this time. Women were treated, we submit, upon the evidence, with particular disgust and cruelty. Children were imprisoned with their parents and held in the exact same squalid conditions as the adults, left in charge of their blooded and brutalized parents. Page 211, please. 211 of the Commission's document. Can I refer this court to the second entry in Zedand? The witness was flogged as her interrogator held her baby girl, who was crying, "No, Mom, no, Mom." She fell unconscious and woke up in a pool of her own blood in which her little girl was sitting. The girl tried to hide the blood from the guards. Nobody took the witness to the doctor, although she was bleeding heavily, and eventually she was transferred. That is the witness, Azar Ali Khan. It is but one example of what we refer this court to. Can I take the court over the page, to page 213? The last entry. So many women were raped. When the witness was first imprisoned, she met Fozzie, who had sores all over her body, was mentally disturbed, and refused to shower because she feared the judge would look at her naked. She describes that she had been raped. and then she was taken by her main interrogator to a mental asylum. The reading, as we've indicated before, beggars belief. It is, we submit, heart-wrenching to hear how children on the evidence constructed their games around their experiences in the prison. One mother made her daughter a doll, only to find the girl playing torturer with the doll and beating it viciously. Minors were arrested and executed as political prisoners in their own right. The youngest on the evidence was 11 years of age. Chapter 5 of the Commission's report describes the ordeal of the families of political prisoners, for it is evidence that we will submit to this court that it is not only the victims, it is the bereaved and those close to the survivors. It tells in Chapter 5 of how these individuals were viciously assaulted, how their visitation rights were curtailed, and how they were notified of their loved ones' deaths with astonishing, we submit, insensitivity. Sometimes the first confirmation that they had was that their relatives were in prison at all, was that they were dead. How countless families were made to pay for the bullets used to kill their relatives in order for those bodies to be released. Page 170. Page 170, just over halfway down the document. After that, my father went to collect his corpse, where the families were asked for money in order to release their corpses. The money was for the bullets that riddled their bodies. The charge was based on the number of bullet holes in their corpses. I cannot exactly remember how much my father paid for my brother's bullet holes. Witness 17, name redacted. Families were denied the opportunity to give deceased dignified burials, and their mourning ceremonies were violently disrupted. And this does not even go anywhere near touching upon evidence of graves then dug up at a later stage, which this prosecution would say was to hide the evidence. I am aware from listening to the learned interventions of this court during the course of the last submissions as to the court's interest, quite properly, in individual responsibility. And I'm not going to repeat the able submissions made by Mr. Arkavan on that point, save to say, of course. They are based upon the approach taken at a very early stage by the steering committee as to how we suggest the prosecution process continues. It can perhaps be best summed up by referencing the Commission report on this point and to consolidate the submissions made before me by referring to the Commission's document at page 64. In that document, it is the conclusion of the report, signed in part by Maurice Koppethorne, who will be giving evidence very soon in these proceedings, that it was the view, as this court will see, in the attribution of the facts, a section, and I paraphrase, that the atrocities, as the prosecution submit, were devised, instigated, executed, or caused to be executed by a single central authority, by a single central authority. Not only, say the prosecution, were those actions overt, but in the state failing to investigate clear evidence upon which blame may possibly be attributed to individual perpetrators, that in itself enhances, we submit, the culpability of the state. And so, we urge this tribunal to consider to that extent the evidence against individual perpetrators, as appears in the Commission's report, in attributing what this tribunal feels appropriate, comment, observation or judgment as to what the state should have done, given what we submit is the wealth of evidence against certain individuals made within the report. Chapter 6, indeed, is the chapter dealing with individual perpetrators. Judges, prison officials, prosecutors and torturers amongst them. Identified, so we submit on the evidence of, shall we put it as neutrally as possible, having a case to answer. There was a dramatic turn of events in 1988 when the guns fell silent on the Iraqi front. After 8 years of war, the Islamic Republic accepted the ceasefire imposed by the United Nations Security Council 598. And the fatwa referred to in Appendix A of the document, which I won't take the court to verbatim, it's there for the court to see, was issued, in which a call was made for the elimination of political prisoners with, quote, revolutionary rage and rancor. Ayatollah Khomeini then established panels, dubbed the Death Commissions, to issue the execution orders. The prisoners were at war with God, it was suggested, and were to be eliminated. Part of the terms of the fatwa, which I say I don't cite in detail, is as follows. I hope that you satisfy the Almighty God with your revolutionary rage and rancor against the enemies of Islam, and that officials were instructed to, quote, show no doubt or concern with details, and to act, quote, ferociously. And so they did. Prisons went into lockdown, and all communication with the outside world was suspended, and the atrocities began again. Prisoners were hauled in front of the Death Commissions. They were grilled, interrogated, and pressed, and tortured about their faith, and then dispatched. Over 5,000 people in the early period were hanged in the space of a few months. There are, of course, enduring legacies of this abuse which live today, some of which this court will hear of. Survivors bear physical scars and even deeper psychological wounds. They have outlived, it has to be said, countless inmates who long ago succumbed to their horrific injuries, physical or psychological ones. Those traumas drove some, and a significant number, to suicide. The nightmares that they speak of and have spoken of, and will speak of, haunt them during the day and haunt them during the night and will do for the rest of their lives. One witness was 5 when her mother was executed. She still has reoccurring nightmares in which her house is under attack, and she begs the Revolutionary Guards to spare her mother, who she loves and needs. These are just as much, we submit, harms, torture and damage caused as ever the physical and bleeding wounds that will be brought to the court's attention. This is why the prosecution now moves to this phase, to assert and prove as best we can responsibility for these grave, widespread and systemic violations of human rights that lie within the highest echelons of the Republic. Upon we submit whose express orders they were carried out. To this end, the prosecution will present the tribunal with a series of expert witnesses, not just eyewitnesses and survivors, who will testify on the nature of the involvement, so we submit, of the Iranian state. In order to refresh the minds of judges and interested parties around the world, this tribunal will hear from 10 witnesses who were imprisoned and tortured during the 1980s. I know the court have their statements before them, and they will find more assistance when these witnesses are called. Their stories bear the same depressing watermark of the 75 testimonies within the report, but each makes a uniquely disturbing revelation, which we submit will assist this tribunal in understanding the grave human impact of this dark and terrifying episode. The prosecution are indebted to witnesses, not all I name now, through no disrespect to those I do not name. Their time over the next few days will come. But thank, for instance, the witnesses of Mohammed Reza Arslan, which the court will see and will hear beginning at page 31 of the bundle of witnesses before this tribunal. I'm not going to preempt it. And there are others. We thank them for their courage in addressing this tribunal. The tribunal will also hear from full witnesses with similar stories, but who have since established reputations for themselves on the very human rights violations to which they were subjected. Prolific writers on the subject, those that have presented papers, learned academic tracts, and other important documents since the abuse that was inflicted upon them. The prosecution also will refer to 2 further witnesses whose family were executed in the prisons of Iran and who have since conducted extensive research into this period. The depth of their knowledge, for instance that of Nima Savestini, a well-known Swedish-Iranian filmmaker who has produced a documentary about the mass executions, and we shall be screening scenes from this film, in which Mr. Savastani interviews a gravedigger who received the delivery of 60 bullet-ridden bodies in Shiraz. We will refer this court to an anthropologist and research scholar at the National Centre for Scientific Research in Paris. She is currently investigating post-revolutionary violence in Iran, and we submit her insight will be invaluable to this tribunal. The prosecution will call upon Dr. Hedayat Martin Dftari, a member of the steering committee, but much more than that. He was a vice president of the Iranian Bar Association during the revolution and was one of the founders of the National Democratic Front. His evidence will, we submit, produce invaluable assistance to this court to demonstrate how the Islamic regime dismantled the existing legal system and replaced it with inexperienced judges, and how the very profession of the law was attacked and undermined. How there were detained members of the Iranian Bar Council who were replaced. This witness himself managed to escape, although a death warrant has since been issued against him. These witness testimonies will establish how human rights, we submit, were violated in Iran on an industrial scale, mercilessly, ruthlessly, and systemically. Finally, the prosecution will call on 2 members of the tribunal's Truth Commission, both of whom are world-leading authorities on the human rights situation we submit in Iran. Professor Maurice Copperthorne, Queen's Counsel, a visiting professor of law at the University of British Columbia, who served as the United Nations Special Rapporteur on Human Rights in Iran from 1995 to 2002. And Anne Burley, Amnesty International's researcher on Iran during those years, of 1972 to 1984, conscious as we are, that in a hearing like this one can only take a snapshot.
British Columbia.
Thank you. In addition to your diplomatic jobs, which were served at the ambassadorial level, and your teaching commitments, did you also serve as United Nations Special Representative on the human rights situation in Iran?
I did.
Was that between 1995 and 2002?
Yes, it was.
Had you also been, or were you also known as the Special Rapporteur?
Yes.
Same job?
Alternate titles.
Alternate titles. As Special Rapporteur, did you prepare reports 3 times a year for submissions to the United Nations?
Yes. Twice to the Human Rights Commission and once to the UN General Assembly.
In the course of your time as Special Rapporteur, did you go to Iran ever?
It was always my ambition to go to Iran. Only once did an invitation come.
Was that at the beginning, the middle, or the end of your
That is the beginning.
Thereafter, did you make efforts to go, but were you denied entry and becoming persona non grata?
I made inquiries regularly, but the answer was consistently that there's no sign of it, only on the horizon.
Therefore, apart from what you obtained by your one visit, your information on the position within Iran came from other reporting mechanisms.
Yes.
I'll come back to those reports and your conclusions from them shortly. Did you, as we heard, become one of the commissioners of this inquiry?
Would you repeat the question?
Did you become one of the commissioners at invitation? Did you become one of the commissioners of this inquiry?
Yes, I did.
The first part of that commission, I beg your pardon, the first part of the inquiry, namely the commission, was held in London in June of this year, and before the commission sat, did the commissioners appoint you as the person to be their chair?
Yes, they did.
Can you now please take this volume, and can you go to a page that we've looked at already? It's page 64.
6-4.
64, yes.
Yes.
This is the conclusion of the Commission's report before the appendices and evidence that was laid before the Commission. Is the signature that we see on that page your signature?
Yes, it is.
Does that signature reflect the unanimous adoption by the Commissioners in July of this year of the Commission's report?
Yes, it does.
Included in the findings of the Commission, we can see on page 64, and in the middle of that page, that the Commission concluded that violations of human rights were devised, instigated, and executed by a single central authority, and as such, the government of Islamic Republic of Iran is the only authority responsible for these acts. Was that the Commission's findings?
Yes, it was.
To come back, please, in the same volume to page 2, which is headed Introduction.
Yes.
And between pages 2 and 11, does this report set out the history of the creation of the tribunal, its proceedings, and its mandate?
Yes, it does.
Would you go, please, to page 4?
Yes.
Just, although the judges had this before them, just to remind ourselves, paragraph 12, at the foot of that page, the Commission's task is to carry out a factual investigation into the breaches of human rights in Iran. The steering committee decided that in view of the prolonged abuse of human rights and the fact that the atrocities of the 1980s represents the worst period in the history of the Islamic Republic of Iran, the Commission's focus should be on that period. And was that indeed the Commission's focus?
Yes, indeed.
And for those reasons?
Yes.
You set out in the introduction, and I needn't take time with it, between paragraphs 19 and 23, some relevant passages of history, that's pages 7 and 8, paragraphs 19 to 23, leading to a summary of the activities of the death commissions.
Yes.
And then you set out the structure of the report. Mr. Cockthorne, I have really only one other question to ask you, but it comes in a number of component parts. When you were making your reports as special rapporteur, acting on information then available to you, were your reports favourable to the Republic, neutral or adverse, in general?
In general, I would say they were. They had a favourable section and an adverse section. Virtually in every report covered two perspectives. One being whether there had been any improvements in any which I wanted to record, and also the areas in which I thought human rights had further deteriorated.
Now, as we know from the opening addresses and indeed from the report itself, evidence before the Commission included evidence of executions, of torture, of wrongful imprisonment, and other violations of human rights. First, were those dealt with specifically in any of your reports as Special Rapporteur?
No, they weren't. They were not at that point yet public.
At the time that you prepared those earlier reports, had you heard anything of this category or these categories of wrongdoing?
I had heard very general comments to this effect, but the persons disseminating it really had no evidence in support of it.
So, as rumour, it could not be included in your report?
That's right.
Following the work of the Commission, and in light of the report of the Commission that you have signed off, I want to ask you simply this one question. Looking back now over the work of the Commission and back to the information available to you when you were the Special Rapporteur, is there anything inconsistent or incompatible between what was available to you in information when you were the Special Rapporteur and the information coming to the Commission in June of this year?
Well, certainly the information coming to the Commission this year was much more complete. I rarely saw a document that was self-evidently valid or important or credible. I normally had to make it up from extensive personal interviews with largely Iranians living outside of Iran who would come to see me, and I made a point of having these in every city I went into, that is, an hour or so of interviews.
And looking back, when you were invited to sign the Commission's report, did your earlier experience cause you any doubt, or were you content, as we've seen, to sign that?
I was indeed intent to sign it. I don't think I felt that anything had been incompatible because we had by that time valid evidence to the conclusions we reached, and I never had those available when I was writing my personal reports.
Mr. President, that's actually all I need ask of this witness, apart from one technicality, as to whether it is he who should produce the report to you.
Just before you conclude your inquiry with the witness,
Can't hear.
you may want to ask questions arising out.
Thank you.
Yes, good morning. I want to ask a question really of the witness. May I address you directly? About the United Nations. Because I do this in the context of the opening statements we heard about this, the Commission and the Tribunal being, if you like, a preamble and a preparation for later action and development of legal recourse. Now, as I understand it, your successor has recommended a comprehensive examination of the 1980s and a body be established to do that, but it hasn't happened. My question is this: what is it, in your view, that the United Nations should be doing and can be doing in pursuance of the very task that we are doing here today?
Well, I think there are many elements to that situation. One of them are that the United Nations, in the instrument we're talking about, namely the Human Rights Commission, is subject to many pressures. And those pressures from some countries are not the same as other countries. And in my experience, I found that often a what shall I say, almost punitive conclusion would not get through the full membership of the Human Rights Committee. So you were constantly facing this sort of situation.
Yes, I'm sorry, it doesn't quite go far enough. The General Assembly has an enormous number of powers which it doesn't exercise and could exercise despite the difficulties on the Human Rights Commission. I mean, are you aware of what the powers are and why they're not exercised?
Well, I would say I have not had the occasion to discuss this with people who are knowledgeable about how the agenda of the Human Rights Commission or the General Assembly is actually put together. What I am aware of is that those bodies are subject to a great deal of contest to get their time, and that they would have to be uniform. That is to say, every country on that committee or council would have to be there with the same agenda, the same objective, and that rarely happens.
Final question. So what do you see as the way forward for this tribunal and its recommendations in its judgment, if it makes one?
Well, it's very much, I think, ad hoc. I hope we're learning from this how much really dreadful activity can be underway, which is not above board, so to speak, or on the table or visible to us. I certainly had no source of information, no source of intelligence. I had what I could read in the newspapers. I did not receive, for example, I did not receive reports from UN, senior UN people in Tehran. They had other agendas, and it certainly didn't include human rights. So there are a lot of things dealing with the structure and orientation of the General Assembly and also the specific commissions such as the Human Rights Commission. Yes.
Thank you, Mr. President. Thank you for your testimony, sir. My question is evidentiary, and it goes to the difficulties that you encountered, both as special rapporteur, but also as the chair of the commission, in producing and assembling evidence of these atrocities. What would you say was the effect of those difficulties on the evidence that you collected, given the fact that you're not able to go to Iran to interview people directly? You relied on some secondary sources in other cases. As a matter of an assessment of law, what do you think are the effect of these difficulties on the kind of evidence that you put before us?
Well, I think it varies greatly on each individual case. I think in some cases it turned out to be in hindsight, to be very accurate. In other cases, it would turn out in hindsight to be not so accurate for a whole variety of reasons. For example, I don't know whether you've had evidence yet or not about the efforts by the Iranian government, as well as individuals sympathetic to the government, to deflect particular investigations and particularly deflect results that they thought I should not reach because they were not based on complete information, in particular because they were not based on the view of the government of Iran.
Thank you. Anything arising out of those questions?
May I ask questions on one topic raised by Professor Nancy? Mr. Koppelthorne, is one of the powers available to the United Nations or to the Human Rights Council establishing a specific commission of inquiry? Are you aware?
Does it have power to establish a commission?
Yes. Is that one? Remember, you were asked, there is a wide range of powers. Yes. One of the things that can be done and is done from time to time to establish commissions of inquiry into particular conflicts.
Yes, this is correct. It does have that power, and it sometimes exercises it. I have seen no inclination either in the earlier part of my mandate or in the last days of my mandate that there would be a majority of members supporting that.
The next question is this. Do you have experience of the effect that commissions of inquiry have? Is it easy or difficult for the United Nations as a whole to overlook a commission of inquiry that makes findings of human rights abuses committed in a particular conflict or a particular country? Do you have experience?
Well, I want to start my answer by saying in my own experience, they overlook my own reports when they're debating the subject.
Yes, but you weren't a formal commission of inquiry. I'm thinking more of the commissions of inquiry that preceded the USAR tribunal and matters of that sort.
I don't think they would be more intimidating.
Forced into hiding in the more or less at the beginning of September or end of August of 1979 for my protests and arrangements for reporting the human rights abuses of the newly established regime. Thank you.
Now, may I turn your attention to your documents in the judge's bundle, which appears as the second witness statement beginning at page 5. Your statement is in two parts. It is a rather lengthy statement of 26 pages, and it is entitled Penal Policy in the Islamic Republic, Instruments of Flagrant Abuse of Human Rights. Is that statement an accurate and truthful reflection of your views about the Iranian legal system based on your experience and expertise?
Absolutely. Thank you.
Now, could you perhaps explain to the court the fundamental basis in the Iranian constitution and by extension in Iran's penal laws of the so-called velayat tabid, the rule by the Islamic jurists? Your statement describes the basis in the Sharia law for Iran's penal legislation and the respective authority of the Supreme Leader Ayatollah Khomeini. Could you briefly explain to the court what the basis of that authority was and what implications it had practically on Iran's penal legislation?
Well, in the new constitution, which was established by the new regime in Iran, the legal system has been based on fiqh, which is Islamic jurisprudence, and not, a special section of Islamic jurisprudence, which is the Dfteri section or the Shia section of the Islamic jurisprudence, as interpreted by the Faqihs or the people like Ayatollah Khomeini, who was at the time established under the Article 5 or Principle number 5 of this constitution as the representative of the hidden Imam, and therefore as the supreme jurisprudent, a position which puts him above the law and above the constitution. And this very same constitution, in its principle number 2, it holds that the law of the land and the practice will be the practices of the jurisprudence of this particular school. And in some respect, when we look back at what happened at the time, they came forward with two points in their mind. One, to destroy the existing penal policy, the existing penal code, and the existing judiciary, and replace it with an Islamic Sharia judiciary. And bring forward a constitutional law or a constitution which would uphold this. And one of the first attempts at this was before actually having a constitution. They started a parallel type of judiciary presided by Sharia judges and working extrajudiciary outside the existing judiciary, because the constitution did not come into force until late in until the autumn of the 1979. And during that time, you had the Islamic revolutionary courts, which were in charge of the affairs, and the actual judiciary had become sort of a fifth wheel in the organization of the country.
Thank you. Turning to your statement in paragraphs 3 to 6, you identify 3 steps in this transitional period where you were the Vice President of the Iranian Bar Council. You explained first that Islamic revolutionary courts were established. Secondly, that the Constitution gave absolute sovereign powers to the Supreme Leader. And thirdly, that in 1982, Ayatollah Khomeini issued a fatwa declaring that all laws that contradicted the Sharia, based on his interpretation, will be null and void. Is that correct?
That is correct.
Now, I would like to address some of the specific crimes under the Sharia law to which you refer in your statement. Firstly, you mentioned in paragraph 6b of your statement that under Article 167 of the Constitution, alleged perpetrators were not required to have legal notice of the existence of their crimes under the law. So what we call the principle of legality, nulla poena sine lege, the requirement that there be no vague or retroactive criminal laws. Was that principle respected in the Constitution of the Islamic Republic?
Not at all, in many respects.
Thank you. Now, you refer to a number of different crimes, and I would like to ask you to elaborate somewhat on those. These explain the crimes of muharrebe, mufsid fil ard, muharrebe being waging war against God, mufsid fil ard refers to the corrupt on earth. Could you perhaps explain to the tribunal the definition of those crimes and how those crimes were in practice applied by the revolutionary courts?
Muharrebe does have some sort of description in the actual penal code, which is the Islamic punishment, the law of Islamic punishment. And it means it includes, but not limits, crimes to people taking up arms against the actual order, existing order. But ifsad fil ard or corruption on earth does not have any understandable actual definition in the law. The definition is left to the judges to decide. And in this very same law, it allows collective condemnation of people, because it says that if an organization, if an organized force is made which has taken up arms against the existing order, all people connected to it, all people who have associations with it, all members who do not have anything to do with the actual armed struggle, and those who and any supporters or any associates, they would all be held responsible for the crimes of the organization. And this was later on, as I have mentioned in this document, which I prepared, and more elaborated by Ayatollah Khomeini himself. And one good example is the fatwa, or in fact it wasn't a fatwa, because fatwa is a legal opinion by an Islamic jurist. What was issued by Ayatollah Khomeini was a judgment and a command against Salman Rushdie. But in this command against Salman Rushdie, he mentions that all those people associated with the work of Salman Rushdie, they are also his allies, and they should also be punished in the same way as is prescribed for Mr. Rushdie himself. This was elaborated by the chief justices in Iran, saying that Ayatollah Khomeini has made things very easy for us, because we do not have to investigate every person one by one. There is collective judgment, and once we know a person is connected with a certain type of affair, then we will be able to execute him within less than a week, rather than going through investigation on the actual individual and establishing the actual individual's act of crime in the country.
Thank you. At paragraph 43 of your statement, you refer to a statement by the head of the judiciary, Mr. Mohammad Yazdi, who makes a statement to the effect that sentences announced by His Holiness the Imam, referring to Ayatollah Khomeini, against persons, such as the sentence of apostasy pronounced against Salman Rushdie, were not simple fatwas or expressions of religious opinion, but sentences of death, which include proper directives for the executioner. He goes on to explain that in relation to groups such as nationalists, liberals, the Hujjati Society, and the Nezdat Azadi, or the freedom movement, which he explains is written in the handwriting of Ayatollah Khomeini, and he refers there as well to the judicial sentence for the Munafiqeen, the hypocrites, which refers to the People's Mujahideen organization. Mr. Yazdi explains that the fatwa issued by Ayatollah Khomeini against those groups means that he has condemned the organization, its organs, and its members in their totality collectively and not individuals separately. So just to clarify, this means that any individual which belonged in groups that were covered by those fatwas could be executed without any further inquiry as to whether they in fact violated particular laws or not. Is that correct?
That is correct.
Thank you. Now, I'd like to take you quickly to a few other concepts of Islamic law which are of relevance to the testimony that this tribunal will hear. In particular, I would like to address the concept at paragraph 53, subparagraph C of your statement. I'm terribly sorry, I have the paragraph wrong here. I'm just going to find the relevant quotation. Here it is, I'm sorry, it's paragraph 15 of your statement. You explained that the use of torture to extract information or confession is forbidden by Article 38 of the Constitution of the Islamic Republic of Iran, but that there is a notable exception in the form of hazir punishments. Could you explain what that exception to torture is according to this concept of Sharia law, and how it was used in order to extract confessions from defendants or prisoners?
Well, I have to first state that what hazir is. There in the jurisprudence that is practiced and on which the law of Islamic punishment is based, there are 4 sections. The first section is the had, or the rights of God, and the punishments for which are actually established, and the Sharia judge cannot change them, except for the punishments for muharib, meaning warrior against God, and mufsid, corrupt on earth. 4 types of punishments are prescribed. One being death, another one being crucifixion, another one being the mutilation of the right hand and the left foot, and the third being banishment, which they have interpreted as being imprisonment of not less than 1 year, pending the repentance accepted by the Sharia judge by the imprisonment, which this could extend to many, many years of imprisonment. As I have recently also seen, a mother of a person who went to visit him amongst the Mujahideen, she was arrested in Tehran, and she was given 10 years of ta'qib, 10 years of banishment, for having gone and shown associations with the Mujahideen. I mean, I'm terribly sorry, I'm deviating from your question. Is it all right?
Yes, yes. Perhaps I can go on to consistent with what you're saying, to turn your attention to the fatwa issued by Ayatollah Khomeini in 1988. It appears at page 67 of the Commission's report. I believe you should have a copy on the table, and I'm sure you're familiar with that fatwa.
Yes.
And at page 67 to 68, you will see a copy of the original Persian text and the English translation. Now, consistent with what you've said about the various Sharia concepts with respect to crimes which can result in execution, we see here in the English translation, in the name of God, the benevolent, the merciful, this is the fatwa of Ayatollah Khomeini. Since the treacherous munafiqeen, which was one of the concepts that we referred to, do not believe in Islam, and whatever they say is stemmed from their deception and hypocrisy, and since, according to the claims of their leaders, they've become apostates of Islam, and since they wage war on God, once again the concept of Mutahharrim, which we refer to, and the fatwa goes on to make a number of allegations of espionage and armed struggle, before concluding that it follows that those who remain steadfast in their position of hypocrisy in prisons, hypocrisy once again referring to the notion of Maqabel, are considered to be muharib and are thus condemned to a sentence of death. Is this fatwa an example of the phenomenon that you are speaking of using very vague general categories of crimes to impose collective sentences of death on political dissidents?
That's it, exactly, yes.
Thank you. Now, I would like to take you to paragraph 20 of your statement, where you speak about how the Sharia law, as interpreted and applied by the Islamic Republic's constitution, did not treat Muslims and non-Muslims equally. Your statement says, and I quote, "If a Muslim kills a non-Muslim from a recognized religion, no retribution is permitted unless the murderer makes a habit of the crime." Could you please explain to the tribunal what you mean by the fact that there is no retribution unless the Muslim makes it a habit to kill other non-Muslims?
Well, if the killer, in fact, keeps on killing the non-Muslims, I mean, he starts a massacre, or serial killing, concepts like that.
For the same occasion, to discuss the revolutionary courts and their composition, you explained that, certainly during the time that you were vice president of the Bar Council and subsequently based on your research, that the existing judicial system as it existed during the government of the Shah was dismantled and replaced by revolutionary courts. Could you tell the tribunal something about the qualification of judges on the revolutionary courts and the degree to which they exercise those functions in an independent or impartial manner in applying the Sharia law?
First, before I mention that, I have to tell you that one of the first tasks of building the Islamic judiciary to, in fact, purge all the existing judges who were trained lawyers and who had law degrees and who were trained as modern judges in the modern judiciary that existed in Iran, which was developed from the 1906 revolution. Under the new system, you only had to be a member of the seminary, or you had to be a mujtahid, but if they were short of mujtahids, they in fact employed members of the seminaries who were students and who would be mujtahids.
Could you please explain to the tribunal what a mujtahid is?
Mujtahid is a jurisprudent, a person well versed with the Sharia laws and who can judge and who can solve problems and explain legal matters to the Ummah.
So the mujtahids or students of the seminary had the authority to impose the death sentence based on these vague categories such as Maqabel and the other categories that you mentioned. Is that correct?
That is correct. But the difference being mujtahid's judgment was final and could not be appealed unless he himself accepted that he made a mistake. But the member of the seminary, which is Talabe, who's not a mujtahid, but he's done some studies in the Sharia law, he could be corrected by a mujtahid at a higher level or at the same level.
And how would you describe the relationship between the Islamic revolutionary courts and the other branches of government, including the supreme leader? Would you characterize those courts as independent or impartial of the other branches of government, including the supreme leader?
I wouldn't, no, I don't. And I have my reasons for it. I've mentioned it in my statement. Because they're liable to dismissal at any time. It's not, they are not appointed for life. Even the Chief Justice or the head of the judiciary is only appointed for 5 years by the guide of the Vali Amr, Vali Faqih, Supreme Jurisprudent. And in fact, they're very much at the mercy of the higher authorities and their orders. In practice, this has been shown on all occasions, more or less, even to date.
Before turning to the final set of questions I have, I want to just return briefly to one other aspect of Sharia law, which is at paragraphs 32 to 36 of your statement, and that's relating to the criminal responsibility of children under the Sharia law. Could you explain to the tribunal what rules applied with respect to the execution of minors, those under 18 years of age? What was the age at which individuals could be sentenced to death under the Sharia laws?
Well, according under the Sharia law, which is repeated in the law of Islamic punishment, and it's not it's the codified version of the Sharia, which is practiced in the country and is subject to revision every 5 years or more. The responsibility begins at the age of puberty, at the Sharia age of puberty. For girls, it's 9 lunar years, which is 8 years and a few months. And for boys, it's 15 lunar years, meaning 14 years and a few months.
So it's correct to say that under the Sharia laws as interpreted by the Supreme Leader, girls as young as 8 years of age and boys as young as 14 years of age could be sentenced to death?
Yes.
Thank you. Now I would like to take you finally to the question of the rights of defendants appearing before the Islamic Revolutionary Courts. At paragraph 49 of your statement, you refer to a statement by the Prosecutor General at that time of Iran. It's a statement which was published in Etelat newspaper on 9 March 1982. The statement is attributed to Mr. Radwani Amnashi, I believe if I pronounce that correctly. And this is what he says about the role of defense counsel. Their attorneys may defend the prisoners provided that at least they have belief in the guilt of these groups as Muharred and El-Hadi, which means atheists, and would be ready to base their defense on the grade of their crime, demanding clemency and lenient punishments. They should not declare that the terrorist, the agent, the Muharred and the Mufsid are innocent and demand their return to the society, enabling them to repeat their crimes. Would it be fair to say that the Prosecutor General in effect is saying that a defense counsel may only plead on behalf of his or her client to mitigate punishment but not to prove innocence?
That is correct.
Thank you. And finally, Dr. Mati Dftari, I would like to turn to paragraph 53 of your statement, where you speak about the treatment of defense counsel, in particular at subparagraph C of paragraph 53, where you refer to the mistreatment of a defense counsel. You say the following, and I'm just going to read briefly, and you can conclude after that, Mr. President. You explain that in December 1981, the International Commission of Jurists recorded that a newly qualified lawyer, Mohsen Jahandar, had been condemned and executed by firing squad in August 1981 for having defended persons on trial in revolutionary tribunals. On 1st November 1981, another young lawyer, Muhammad Reza Bakhtiyari, who defended political prisoners, members of the Mujahideen, was executed solely for having undertaken the defense of the enemies of the regime. Other members of the bar executed in this period included Manouchev Massoudi, the former legal advisor to President Banisad, Zia Modarres, a prominent lawyer and former assistant disciplinary prosecutor of the bar, Dr. Mahmoud Mansour, Mehdi Amin Amin, a veteran lawyer of prominence, former legal advisor of Iran National Airlines and a leader in the Baha'i faith, and Dr. Manouchev Baha'i Mahali, also of the Baha'i faith. So would it be fair to say that being a defense counsel in the Islamic Republic was a hazardous occupation?
I didn't get your last sentence.
Would it be fair to say that those that defended their clients before the revolutionary courts would expose themselves to significant risk of arrest, torture, and even execution?
I definitely think so, because I only know of 3 lawyers who tried to defend, which I've mentioned in the statement. And the situation was such, harassment in such a manner that lawyers did not dare to get near the tribunals, and those being tried, going through brief trials and summary trials, and not having any contacts with the outside. They had no chance whatsoever, neither themselves nor their family, to contact lawyers and ask them to defend them. So, I mean, there was a sort of atmosphere of, in fact, harassment, that no one did anything at all. And this is what they best wanted. They wanted best for what they were doing at the time. Because under their concepts, although Rabbani Amlashi and his other colleagues have always mentioned that under the Sharia law, wakalat or the presence of counsels and lawyers are permitted. What they actually, in fact, mean is ordinary power of attorney for doing errands for you. And as far as they were concerned, they did not need trained members of the bar. They thought any person who takes a wakalat to do something on behalf of someone. I mean, this is how they actually define the concept of attorneyship, and not what we understand as the right of defense and the duties of an attorney at law and the person who is there to actually exercise the right of defense in favor of people who are being tried in the courts of law.
Thank you, Dr. Mr. President. In keeping with the schedule, that completes my questioning. I leave it to the court.
Thank you. A number of members have questions. If you would deal with them now, I think it would be more convenient. Professor, well, let's start at the far end.
Yes,
Yes,
thank you. I'll be very quick. 2 weeks ago, I addressed the International Bar Association. There were 5,000 members in Dublin. I'm concerned about the independence of the Iranian bar, which had a very high reputation. The question is, did you ever get any support from the International Bar Association? Has this issue been raised by the International Bar Association to provide solidarity?
Well, very little support at the time when actually the bar was at the point of being completely suppressed by this regime in Iran. Because the regime thought that by the suppression of the bar, they would open the way for the type of justice that they wanted to establish and to practice. And the right of defense should disappear so that the one-man justice of a judge being both prosecutor and counsel for defense, as well as juge d'instruction, would act. I'll tell you something which I experienced myself at the time. I was in Europe, and my colleague, the other vice president of the bar council, who was appointed by the bar to represent the Iranian bar at the organization you mentioned. Exactly. He was informed after the bar was taken over by the Iranian regime and the newly qualified lawyer was put in charge of it. He was informed that he has paid your membership fees and you cannot come to our meetings anymore.
Professor, thank you very much, Mr. Dftari. Much of your testimony has centered on jurisprudence, on the interpretation of Islamic law. And I just want to hear from you, if you could state clearly for the tribunal and clarify a number of issues. One, is it your view that Sharia law is not compatible with justice, or not compatible with the idea of human rights? Do you take the view that the concepts of Monafikin, for example, or Mofsed in ours, those who are corrupt on earth, or even the concept of Muharrem, those who are at war with God, do you take the view that those are corruptions of Islamic law by the Republic of Iran,
Those are what?
Corruptions of Islamic law. Or do you take the view that that Islamic law is really illegitimate and incompatible with human rights and justice, and that it should be replaced with secular law in Iran? I think it's important for you to clarify this for the tribunal so that we are clear about whether the disagreement that you have with the Republic is one of Sharia law, period, or the Republic's interpretation of Sharia law.
Well, I take the view that what has been imposed on Iran and what is practiced in Iran as Islamic law is incompatible with justice and human rights.
Do you take the view, though, that there is a version of Sharia law that could be compatible with justice and human rights?
Well, since I'm not a Sharia lawyer, and since I have only had access to what was presented to me by this regime, all I know about the Sharia law is what they have presented in various documents and in the form of the law of Islamic punishment to us. And that is incompatible with modern justice. It's a clash between an ancient school and the results of modern development in human rights and the results of the age of enlightenment which we enjoy at the moment in the form of human rights, the Universal Declaration of Human Rights and other concepts which are around it.
Let me just press Mr. President one more time. Is there a place, any country in the world where you could imagine legitimate Sharia law being practiced?
I do not know.
Thank you.
Thank you for your testimony. I have two briefly interrelated questions. You have given evidence concerning the age of criminal responsibility of children. And in terms of girls, you stated it's near the age of 9, a little bit under, and for boys, it's near the age of 15. Well, according to those legal precepts, does that mean that girls under the age of 9 or boys under the age of 15 cannot be jailed because they cannot be criminally responsible for their acts?
That's correct. And in the clear concept, yes, it is correct.
And then my second question is that if those boys or girls under the age of criminal responsibility were unrecognized religious minorities, would that be an exception to the criminal responsibility, or are they also protected as children, even though they might be unrecognized religious minorities?
Well, I must elaborate that matters such as these are silent in the law. They have not written anything about it. It's been under the Article 167, I believe, it's Principle 167, I believe, of the Constitution. The Sharia judges are given the full power of implementing whatever they think is the law and not what is written in the codes. Therefore, I mean, much of the matters which are to be dealt with in this society and much of the matters which are dealt with, for example, things like hypocrisy or things like atheism or a few other concepts which are also punished and punished under the Sharia law. They don't have a place in the actual the Islamic law, the law of Islamic punishment. The law of Islamic punishment has only codified certain parts of the law which by the actual mujtahids in the courts. And they are directed to refer to existing documents, existing sources by various other jurisprudence, various other faqihs. As far as the children are concerned also, which you have mentioned, may I just add that Iran has become, has actually ratified the Convention on the Rights of Children, on the rights of the child, with many exceptions. And that means they have gone so far, as I have mentioned in my document also, in more details, insofar as that more or less it's as though they have not ratified it. And this has been protested by the committee concerning the convention, and coming into terms in some manner. And what is practiced right now, if a child at the age of 16 or 17 murders anyone, he's condemned to death, but he's not executed until he attains the age of 18. And he's kept until the age of 18 in prison. Then, on his birthday, he's liable to be executed. And we've had many cases.
Thank you very much, sir. Thank you for the trouble you gone to prepare your statement and your evidence for us. We are indebted to you. You are excused. I think we will stand adjourned until 2 o'clock.
I apologize. Would it be possible for me to direct 2 very questions to Dr. Mtn?
I should have asked you. It's my fault, not yours. Please go ahead.
Thank you, Mr. President, for your indulgence. Very quickly, Mr. Dfteri, we have several statements in the Commission's report, which my colleague, Mr. Cooper, alluded, where children under the age of 8 and 14, respectively, were in prison with their parents. So, to the extent that it is true that children could not be sentenced to prison, would it be accurate to say that many of them were in effect imprisoned by virtue of the imprisonment of the parents?
Well, they were not considered as prisoners. They were considered as people who have to stay with their mothers.
Thank you. And finally, would it be correct to say that in your statement you have not appeared as an expert on Sharia law in order to determine whether Sharia law could potentially be reinterpreted in some other light, but that you have restricted your statement to statements of fact as to how Sharia law was in effect interpreted and applied by the Islamic Republic of Iran during the years that are relevant to this tribunal. Would that be a correct understanding of your statement?
That is good.
Thank you, Mr.
Could I just put that question slightly differently? As I understood you, sir, you were not trying to interpret Sharia law at all. You were telling us what was said to be Sharia law in Iran nowadays.
Yes, what's practiced in Iran nowadays.
As practiced. Whether that is Sharia law or not, you express no opinion. Thank you. We stand adjourned until 2 o'clock.
Everyone rise.